members, we will go ahead and officially reconvene our meeting that we took a recess from yesterday. Good morning, all. If I can have Ms. Taylor please call the roll.
Good morning. Chairman Vasquez.
Present.
Vice Chair Schaefer. Vice
Present.
Chair Schaefer.
Present.
Member Gaines.
Present.
Member Cohen.
Present.
Deputy Controller Stowers.
She was going to be late.
The Deputy Controller will arrive briefly. She had another commitment, but she will be joining us later this morning.
All righty, so we do have a quorum, so we will officially reopen this meeting. And with that, I'm going to just remind everybody once again, especially after this little hiccup we had this morning with our technology, that we are all on one line that we're sharing. So please, your patience is greatly appreciated. And once again, like we always do, and you've been very good so far, to identify or at least give me a sign that you are requesting to speak, so we can make sure that our transcriptionist is taking clear and properly recording this the minutes. So with that, I'm going to ask Ms. Taylor to please announce our first order of business.
Mr. Chair, would we like to start with the Pledge of Allegiance?
Sure. Well, I understood if we were continuing the meeting, we don't have to, but sure, we can do it. All right. Let me have everybody stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Okay. Thank you all.
All right.
And with that, Ms. Taylor, if you can call the first item of the day.
Our first order of business is an announcement regarding the public teleconference participation. Good morning, and thank you for joining today's Board of Equalization meeting via teleconference. Throughout the duration of today's meeting, you will primarily be in listen-only mode. As you may know from our public agenda notice and our website, we have requested that individuals who wish to make a public comment fill out the public comment submission form found on our additional information webpage in advance of today's meeting. Or alternatively, participate in today's meeting by providing your public comment live. After the presentation of an item has concluded, we will begin by identifying any public comment requests that have been received by our board proceedings staff, with the AT&T operator providing directions for you to identify yourself. After all known public commenters have been called, the operator will also provide public comment instructions to the individuals participating via teleconference. Accordingly, if you intend to make a public comment today, we recommend dialing into the meeting on the teleconference line, as the audio broadcast on our website experiences a 1 to 3 minute delay. When giving a public comment, please limit your remarks to 3 minutes. We ask that everyone who is not intending to make a public comment, please mute their line or minimize background noise. If there are technical difficulties when we are in the public comment portion of our meeting, we will do our best to read submitted comments into the record at appropriate times. Thank you for your patience and understanding.
Is that it, Ms. Taylor?
Yes, it is.
Thank you. With that, members, we will discuss and try to reach an agreement on the 5 non-consensus items remaining from the September 23rd AAB work group meeting. Each of you received in a memo dated November 3rd that, excuse me, that the suggestions reflecting the prior discussions on each sub-issue. These suggestions are intended as a starting point to try to reach consensus today. Our goal is to reach a consensus on each so that the board may approve and refer the language to the executive director for publication in a second LTA. If we end up with sub-issues where no consensus is reached, then we will revisit it in with more time in our next month's meeting. To facilitate this discussion, I will ask Ms. Taylor to announce each non-consensus sub-issue and read the suggested language in the November 3rd memo. I will then call on each work group participant to state how they would suggest changing it. Then, when it appears we are close to a consensus, I will call on the members, specifically Member Cohen's deputy, Regina Evans, to identify possible consensus language. And then we will call for a motion from the board to see if in fact there is a consensus on those issues. One of the things I wanted to stress, I know, we've been discussing these issues quite a bit over these last 6 months. And this hearing, in the interest of time, I would appreciate, especially from our partners and our participants, if we could try to limit our discussion to those issues and items and suggestions you may have that we really haven't had the opportunity to deliberate or discuss in our previous meetings. Otherwise, I could see us pretty much rehashing everything that we talked about over the last 6 months. So with your patience on that, I would really appreciate that. And also, we do have a few, I should say, unresolved items from our prior meetings that may not be fully addressed in this letter to the assessors that the executive director will be issuing today. We will address these issues if we have time in our December meeting. And with that, let me turn to my co-chair on this, Member Cohen, for her opening remarks. Member Cohen.
Thank you, Mr. Chair. Good morning, everyone. It's good to be back with you. As I transition back into work, I have a question for you. It is my understanding that month's meeting, my chief deputy provided a summary, and I wanted to know for what was the reasons, like what led to her stepping into this leadership role, what transpired. Mr. Vasquez.
I'm sorry, you're kind of breaking up on me. What was your inquiry?
How my connection.
You're breaking up.
Actually, you have a really poor connection. Yeah, I have a poor connection. I don't know if it's connected to some of the challenges, but I was asking because you mentioned at the top of the remarks that my chief deputy provided the consensus or measure, and I was curious to know how that came about.
Oh, well, at our last meeting where we had this discussion, you were obviously out, and we allowed her to participate in the discussion as basically representing you as one of the partners from the board, along with the other partners that we had from, for example, from CAA and some of the other respective groups that were weighing in. And that's where it kind of stems from.
All right.
Did you want to do, I mean, I'm open if you want to make some changes then.
I appreciate that being open. No, I think what we should do is just stick with the established plan, and perhaps next month, if this continues, I can step in. But so my chief deputy is going to summarize the consensus, and I think that this is a good opportunity to say some good things on the record. I mean, we've done a tremendous job from what I understand. I'm really elated to learn that that you've made great progress in this topic. The County Board of Equalization and the Assessment Appeals Board workshop. I mean, this was actually incredibly important, and so I'm really pleased that we're moving forward. So without further delay, we can begin. Thank you.
Thank you. Members, do we have any other questions, remarks from any of the other members?
If I could,
Member
Chair-
Gaines, yes.
Member Gaines. Yeah, I noticed that the California Alliance of Taxpayer Advocates has provided suggestions. Looks like some edits and maybe a few additions to our Assessment Appeal Board Collaborative Work Group. So I imagine that they're gonna, at some point, we're gonna hear their testimony, and then we're gonna take a look at their suggestions and see if those should be incorporated.
Yes.
Okay.
I think we're all looking at this for the first time, so
Yeah.
we're going to allow them to make their presentation, and then let's see what the will of the members are.
That's great. Thank you.
Chair Vasquez, Vice Chair.
Yes,
Schaefer.
Vice Chair, go ahead, Vice Chair Schaefer.
I'd like to clarify whether Regina Evans was participating as a board member or as a committee member.
No.
No, she, as far as I understand, and Member Cohen could verify this, as a committee member, and that's where she came in, as a committee member from the last meeting or the last session we had.
Sure, well, she was very constructive. I appreciate that. Thank you.
Yes.
Sorry, my connection is fading in and out. I missed that last part.
Is that, Member Cohen, I was just mentioning to Vice Chair Schaefer that your chief deputy is basically participating as a participant, not as
A member
committee
of the work group.
Right.
As a
Yes.
member of the work group, yes.
Exactly. Okay. And you're freezing up on me again. I hope you heard that. Okay. Let me have Ms. Taylor please call the first non-consensus issue and sub-issue.
Good morning. Our first and only item of the day is item 8A, COVID-19 County Boards of Equalization Assessment Appeals Boards Collaborative Work Group, Consensus Guidance, Letters to Assessors, AAB Remote Hearings, Non-Consensus Items. An update on the impact of COVID-19 on property tax administration, County Boards of Equalization, Assessment Appeals Boards Remote Hearings, and presentation of the work group's findings and recommendations for discussion and possible board action on non-consensus items for guidance on procedural and due process issues in remote hearings, the submission of evidence, technical steps to ensure audio-visual continuity and equal access, the protection of the rights of all parties, and the potential issuance of a letter to assessors. Our first issue is issue B, appropriate methods for dealing with document submission, and the first sub-issue is sub-issue 1, requirements and protocols for entering all evidence electronically at or before a hearing. Would you like me to read the suggested statements?
Yes, please, Ms. Taylor, if you please could read the suggested statements.
Thank you. The suggested statements are: counties may require the electronic submission of evidence up to 72 hours before the commencement of a remote hearing, but are encouraged to require only 48 hours. Counties may require evidence submitted by hard copy, U.S. mail, to be submitted up to 7 days before the commencement of a remote hearing, but are encouraged to allow exceptions as appropriate. The second statement, evidence submitted by a party prior to the commencement of a remote hearing must not be made accessible to the other party until the hearing commences and the party introducing its case in chief enters it into the record. And that completes that item.
Thank you. I will call on the AAB work group representatives so that each group has the opportunity to speak. Will the speakers representing the AABs please address possible consensus language or sub-issue B1?
Excuse me, Mr. Chair.
Good morning.
Yes, I'm sorry, before we start with that, Member Cohen has a question.
Thank you. This is just a point of clarification, just so we're giving equal time to all parties.
Yes.
I think Board Member Gaines mentioned that we've got a letter from CADA. I think we also have a letter from the California Association of Clerks and elected officials. That
Yes,
should be also
we,
acknowledged and read in the record.
we will have that read into the record as well.
Okay, thank you.
Thank you.
Mr. Chair and members of the board, this is Thomas Parker of Los Angeles County. The CACEO would suggest only one change to sub-issue 1 of issue B, and that would be use of expressing time periods in business days, quote, end quote, as opposed to hours. The reason for this is that it would not be very practical for parties to say on a Thursday or Friday, I'm going to submit the documents, or on a Saturday for that matter, when the AAB is only open and available Monday through Friday. So the only change we would request is the use of business days to define the time periods. Otherwise, we have no problem with this.
This is
Thank
Marcy
you.
Berkman from Santa Clara County. I concur with the suggestion that business days be used, particularly as Mr. Parker mentioned, we wouldn't want documents first coming in on Saturday for a Monday hearing. In a time when the counties are mostly about to commence layoffs and in budget crises due to the pandemic, we wouldn't want to have to force clerks overtime in order to upload the documents in the system for a hearing, and therefore we recommend business days.
This is Kathy McClellan from Sacramento County, and I also concur with this to change it to business days instead of hours.
This is Don Gagel, Southwest County Assessor, President of CAA, and as a member of the working group. This makes sense. I think from what I've seen, we're all in agreement about timelines, but the business days makes much more sense than the hourly indication. Thank you.
Good morning, members. This is Brianne Rabowski on behalf of CADA. I hope everybody's doing well. I just wanted to start by, as Member Cohen said, just great appreciation to the board and the efforts that have all gone in, both from the board members, the board staff, each of the working group. This has been a tremendous effort with a fantastic result thus far, and we just very much applaud these efforts. We also wanted to state on the record that this work group model of working with board staff and assembling interested parties through a working group is incredibly productive. It's incredibly useful. We've really found it to be a fantastic model to get things done in a more expeditious manner. We noted that the BOE did publish its first LTA this morning on remote hearings, and we thank you for that. As the chairman noted, and I think Member Gaines noted as well, CADA did provide a letter dated Monday, November 16th. At the end of that letter, we share additional topics that are not presently covered by the November agenda. We encourage the board to consider those items for inclusion in the December agenda. However, to be respectful of the agenda we have today, I will not rehash those. I will not go through each of those methodically, but we do encourage you to consider and look at those. Moving specifically now to sub-issue B and sub-issue 1 for that, we agree having a change to business days as opposed to hours is not anything that we think that's appropriate and consistent with what should be included in the subsequent LTA. There is one caveat, and this really is just an encouragement, not something that necessarily needs to be included in the LTA, but we would encourage counties and clerks to adopt something closer to a 48-hour cutoff. As the working group has stated several times and in consensus, the goal is really to be consistent with in-person hearings. And of course, in in-person hearings, evidence is submitted at the time that it's being introduced. So we think cutting it down to 48 or even less hours to the extent that the boards and the clerks can accommodate that is a good goal to have, but we are in agreement with the stated language as revised to refer to business days as opposed to hours. Subsequently, on the second subpoint for sub-issue 1, we don't have any big changes to this particular topic, but the concern that we had in the statement that's included in the agenda about whether or not evidence should be made accessible to the other party is the language as stated in the agenda seems to only address case-in-chief evidence. And of course, there's all sorts of evidence that may come into play, rebuttal evidence, all other things. So the language that we've included in our letter suggests that we just state subject evidence so that we're not closing the door or making any different rules. So all evidence. So let me read into the record how we would suggest this second bullet point would read. It would read, in compliance with Rule 313 and as required for in-person hearings, evidence submitted by a party prior to the commencement of a remote hearing must not be made accessible to the other party until the hearing commences. And now I'm on the language where we suggest a revision. Our suggested revision is the subject evidence has been introduced. So that very last clause after the and, we're suggesting a slight revision to that language. Thank you, members.
Thank you. Do we have?
Santa Clara County. I concur with the proposed revision.
This is Thomas Parker of Los Angeles as well. So do I.
This is Kathy McClellan with Sacramento, and I do too.
This is Don Gakel, CAA. I concur.
I think that's all. With that, let me call Ms. Evans as the speaker representing the board to summarize and identify consensus. It sounds like we're pretty much in agreement on this, but let me make sure I'm not missing anything here.
Thank you, Chair Vasquez. Based on the comments made by the work group members, there is consensus to accept the language as drafted in the board document with 2 exceptions. There is a request to define the days as business days, as well as accepting the language offered by CADA in the last section of bullet 1. And I won't reword it, but it is what's delineated in their letter and read into the record by Brianna. Please excuse me, I can't recall your last name.
Brianne Rabowski, thank you.
By Ms. Rabowski, thank you.
Sorry.
And I think for the parties, have I captured that properly? Work group members?
On behalf of CADA, yes, Ms. Evans, that's correct.
Don Gakel on behalf of CAA, yes.
Mr. Parker and Mrs. Berkman?
Yes, this is Thomas Parker. You have captured it, yes.
This is Marcy Berkman. I agree.
And is there one additional work group member on the line?
This is Kathy McClellan with Sacramento, and I agree as well.
Thank you. Chair, I think we're okay to go to the next item.
Okay, before we move on, let me just ask the other members, are there any comments or questions from any of the members before we move on to the next item?
Vice Chair Schaefer here.
Yes, go ahead, Vice Chair.
I noticed that there was a requirement there be a hard copy provided as opposed to electronic copy. Is that open to U.S. mail, personal delivery? I've had items lost in the U.S. mail, and it's been my custom when I've been presenting things, as an attorney that I take a copy, hard copy, to the court clerk and get it stamped in. I understand from registered or certified mail, we can get a tracking. I'm just fearful that somebody may want to send a hard copy document and it just does not arrive. So I would hope that there's the alternatives open to the presenter to use U.S. mail, personal delivery, accountable mail. We're not specifying that they have to use common ordinary U.S. mail. So, is there any response to that?
Member Schaefer, this is Brian Rabowski on behalf of CADA. I concur. I think that makes a lot of sense. And I think the way that you would do that is you would just delete the parenthetical in the middle of the first bullet point so that it no longer referenced U.S. mail. I think your point is very well made and taken.
Thank you.
Marcy
This
Berkman,
is
Santa
Thomas.
Clara County, I concur.
Thomas Parker from Los Angeles County, I concur as well.
Don Gagel, representing CAA, I concur.
Kathy McClellan, Sacramento, I concur.
Chair Vasquez, I have
Yes.
captured that amendment in our notes. And so it's just deleting the U.S. mail in that first billet. And I think that is consistent with what everyone just said they agreed to.
Thank you. And moving forward, let me just ask staff, is it understood or do we need an official motion that basically approves what we just heard as a consensus?
Chairman Vasquez, this is Chief Counsel Henry Nanjo.
Yes.
It is the board's option whether they take all the change, have the discussion and make all the changes through one motion at the end, or if you do it as you go. So that would be the chairman's preference or board's preference.
I'm comfortable if the members are comfortable just hearing it all, and then where there's consensus, we'll all group it in one big motion at the end, if the members are comfortable with that. I'm seeing
Yeah.
nods.
Member Gaines is fine with that. Thank you.
Yes, was that Ms. Evans?
Yes, I'm just wondering from a process perspective, if we're going to follow the process we used last time. Maybe Mr. Nanjo can help us sort of review that process. I don't recall the board actually taking a motion, or maybe they did, just for clarification, so that we're consistent in our process.
Sure. I thought it was just a consensus, but let me ask Mr. Nanjo.
So again, it would be the board's preference. One of the things, if the board wants to just indicate their preference, consensus, and then provide that direction to staff, then we can draft the LTA accordingly and recirculate it to the board members on a preview basis. So that is an option, or if the board wants to be more formal, they could do it by motions.
But hearing the question in terms of being consistent, it sounds like that's what we did last time when we gathered up. I thought we just kind of had a consensus, and then we had you folks at the end. Actually, we voted at the end on all the changes where there was consensus, and then we just directed staff to develop the LTA. If people are comfortable with that,
that's correct.
Okay, that's the way I'm heading, unless I hear any objections from the members. All righty. With that, let me have Ms. Taylor, if she would. Well, you know, I guess before we move on, do we need to hear from anybody else from the public that might have some comments?
Mr. Chairman, Ms. Taylor
Yes.
here. We do have a written comment.
Sure. Do you want to read it?
Yes, please. This is a comment from Ben Lee. The California Taxpayers Association thanks the Board of Equalization for taking the lead on the issue of providing the option of remote hearings for assessment appeals, and we appreciate all of the work done by the working group. In addition to the short-term benefits during the pandemic, remote hearings could be a good long-term option for the convenience of taxpayers and could help assessment appeals boards with workload issues. As with all things, the details are important, and the due process rights of taxpayers must be protected first and foremost. We appreciate the working group's attention to these details and the board's deliberative process to anticipate and address challenges associated with providing a remote hearing option. That completes the written comments.
Thank you. Ms. Taylor, do you want to check with AT&T and see if there's anybody on the line?
Yes. Can the AT&T moderator check to see if there are any public comments on this matter?
To make your voice heard in the public comments, you may place yourself in the queue by pressing 1, then 0 on your telephone keypad. There is no one on the phone lines queuing up at this time.
Thank you. Ms. Taylor, if you would please call the second non-consensus sub-issue.
Our second non-consensus sub-issue is sub-issue B2, timing for electronic submissions, day of the hearing submissions, protocols on presenting documents for witness impeachment. The suggested statements are, in compliance with Rule 313, counties shall allow day of the hearing electronic submissions in remote hearings for all rebuttal evidence and documents for witness impeachment and for correcting errors as appropriate. At the hearing, either party may introduce new evidence relating to information received from the other party, but the other party, upon request, shall be granted a continuance for reasonable time. Thank you.
Thank you. Will the speakers representing the AABs please address the sub-issue B2 if they're on the line?
Thank you. This is Marcy Berkman, Santa Clara County. We concur with the first sentence regarding admission of the rebuttal and impeachment and correcting evidence. However, the second section, the second sentence appears to have been inappropriately lifted from Revenue and Tax Code section 1606 and Property Tax Rule 305.1. And those sections refer to when there has been a formal exchange of information between the parties 15 days before the hearing, and what happens when somebody introduces related evidence during a hearing, and then you have a continuance. And while this language is appropriate in that context, here in the context of remote hearings, while the parties are turning in their information to the clerk to facilitate the electronic uploading of the data, they are not exchanging it. And we believe it would be inappropriate to import that language into the remote hearing process and would create a system where the rules governing remote hearings and the process for how they happen would be entirely different than the rules governing live hearings. And I think all are in consensus that as closely as possible how remote hearings are conducted and the process and the due process provided is the same as in live hearings. So we would request striking that last sentence that begins at the hearing and concludes with reasonable time. Thank you.
This is Thomas Parker of Los Angeles County. I concur with what Ms. Berkman of Santa Clara just said.
This is Brianne Rabowski on behalf of CADA, and if I could request Ms. Berkman, can you please clarify whether or not you would agree to the first half of that second sentence we've been discussing? In other words, would you be amenable to keeping at the hearing, either party may introduce new evidence relating to information received from the other party?
I think the first half that what received from the other party implies an exchange. But if that were to be changed to introduced at the hearing, then I would be amenable to that portion. However, I do believe that that's already covered in the first sentence of the bullet under sub-issue 2.
Okay.
Any other comments from any of the partners?
This is Don Gakel of CAA. We concur with the CAA CEO position as explained by Ms. Berkman.
Thank you. Anybody else?
And Brianne Rabowski, just to follow up on behalf of CADA, hearing Ms. Berkman's explanation and looking at the CA CEO letter that was provided yesterday, I think we can concur that deleting the second sentence makes good sense. And I do agree with Ms. Berkman that it incorrectly references formal exchanges of information under section 1606. So I think we agree with deleting that last sentence in full.
Thank you. Anybody else?
This is Kathy from Sacramento County. I also agree with Ms. Berkman on this first portion, first sentence of this section, but not the second half.
Thank you. Anybody else out there? Hearing no others, let me have Ms. Evans, we could just summarize and identify the areas where there is a consensus, which it sounds like it's on the first part of this paragraph.
Thank you, Chair Vasquez. It appears the consensus centers around accepting the bullet as drafted as long as the second sentence is deleted.
Exactly, that's what I'm gathering as well. Any questions from any of the members? Everybody seems to be okay with that. Let me see if there's anybody. Ms. Taylor, we don't have any written comments on this one, do we?
We do.
Oh, we do?
Yes. Would you like me to read it? This is from Rebecca Archer. Dear members of the board, I'm writing to express concern that a proposed rule for remote hearings may create confusion in the law. Specifically, sub-issue 2, timing for electronic submissions, day of the hearing submissions, protocols on presenting documents for witness impeachment, refers to Rule 313 and states in part as follows. At the hearing, either party may introduce new evidence relating to information received from the other party, but the other party, upon request, shall be granted a continuance for a reasonable time. However, this is not part of Rule 313. The concept advanced that a party has a right to a continuance where they have not previously been accorded access to information is contained only in formal information exchange statutes. Revenue and Taxation Code Section 1606 and Rule 305.1 provide the rules for an exchange of information that would invoke this type of continuance in certain circumstances. Such dispensation, however, would not be allowed in a regular hearing where no such exchange occurred. In fact, it appears the language is taken in large part from Section 1606D and the last sentence of Rule 305.1C. Therefore, I do not believe it is proper to add this language to rules for remote hearings, as it alters the legal landscape normally present in hearings. This proposed rule should be revised either to say that the continuance is only available where a formal exchange of information was invoked under Section 1606 and Rule 305.1, or taken out altogether. Thank you for your consideration. That concludes the written comment.
Thank you. Ms. Taylor, can you check with AT&T and see if there's anybody in the public?
Yes. AT&T moderator, do we have any public comments on this matter?
Once again, to place yourself into the queue for public comment, please press 1, then 0 on your telephone keypad at this time. There is no one queuing up on the telephone lines for public comment at this time.
Thank you.
Thank you. Ms. Taylor, if you would please call the third non-consensus sub-issue for us.
Our third non-consensus sub-issue is sub-issue B3, required platform for document submission and required format for documents, parentheses, Word, PDF, Excel, etc. The suggested statement is PDF documents are preferred in order to protect document integrity, but other forms may be accepted by the AAB clerks as appropriate.
Thank you. Will the speakers representing the AAB please address this sub-issue B3?
Mr. Chair and members of the board, this is Thomas Parker from Los Angeles. We agree with the language.
Thank you.
Brianne Rabowski on behalf of CADA, we also agree.
Don Gagel on behalf of the CAA, we also agree.
Marcy Berkman, Santa Clara County, we also agree.
Kathy McClellan, Sacramento County, and we agree.
Anybody else? Hearing none, let me ask Ms. Taylor, because this one seems to be a pretty easy one. Do we have anybody from any written comments on this one?
Chairman, we do not have any written comments.
So Ms. Evans, I was going to get you back to summarize, but I think this is a pretty easy one to go forward, no?
I agree, sir.
Thank you. How about Ms. Taylor, if you can please check with the AT&T and see if there's anybody on the public line.
Yes. AT&T moderator, do we have any public comments on this matter?
If you wish to make a comment at this time, you may place yourself into the queue by pressing 1 and then 0 on your telephone keypad. There is no one queuing up for public comment at this time.
Thank you.
Thank you.
Members, is there any comments or questions on this item before we move forward? Seeing and hearing none, we will move on to the next item. Ms. Taylor, if you would please call the next item, which is, I guess, our fourth non-consensus sub-issue B4.
Yes. Our fourth non-consensus sub-issue is sub-issue B4, ensuring parties and AAB members can view all documents during hearings, necessity for simultaneous viewing. The suggested statements are: all parties must be able to present evidence, written and oral, as well as direct cross-examination of witnesses and documents in real time at remote hearings, per Rules 302A1 and 313E and RTC Sections 1609 and 1610.2. The board must also be able to view all documents and hear all parties in real time in order to render its decision only on the basis of proper evidence presented at the hearing, in compliance with Rule 302. Additionally, the public must be able to hear and observe the remote hearing as required by RTC Section 1605.4. Technological platforms for remote hearings should have the ability for evidence to be viewed in real time and the ability to prevent confidential documents from being viewed by the public. In the event of a connectivity problem, the absence of an available IT resource or other challenge, the AAB has legal authority to grant a continuance as it deems appropriate. And that concludes.
Thank you. Do we have our representative from the AAB to address this issue?
Mr. Chairman, and board members, this is Thomas Parker from Los Angeles. We have no inherent problem with the language in what I'll refer to as the first bullet in the chairman's letter. We have a technical issue with the last sentence, which is additionally, the public must be able to hear and observe the remote hearing as required by Revenue and Taxation Code Section 1605.4. The technical problem, at least in Los Angeles, is this. With the WebEx program that we have, the public can listen to the hearings. If they wish to observe with their eyeballs, they're going to have to be on the same, have to have the same status for the WebEx program as the parties, which means that's how they get to see, they would see the documents as they are introduced by the various parties during the hearing. Now, in an in-person hearing, the public would not have immediate access to the documents that the parties are introducing and discussing in the hearing. And that's not to say they are not public documents, but a party could not, a member of the public, I should say, in the middle of a hearing could not stand up in an in-person hearing and say, I would like to see document XYZ that's just been brought up into discussion by the parties in the middle of a hearing. And given the technological program that Los Angeles County is currently using, the members of the public in a remote hearing would have an additional advantage that they don't have and are not required to have in an in-person hearing. So we are not against the public seeing non-trade secret documents in a AAB hearing. That is public, those are public documents as a matter of law. But as a practical matter, it would be less than efficient to have to make copies for individuals in an in-person hearing of the documents. And the question arises, and I don't know what the answer is, do the parties want to immediately make their non-trade secret documents available in the middle of a hearing to a member of the public? So the use of the word observe, because of this technical issue, raises a potential practical problem in Los Angeles's view.
Thank
This
you.
is Marcy Berkman, Santa Clara County. I concur with Mr. Parker's remarks. In Santa Clara County, we are not currently using remote hearings, but for the last several years, all of our live hearings have been broadcast via Shoutcast, so that public that prefers to listen from home or their offices may listen to the hearings from home. And if we were to go remote, I don't know what platform would be adopted, but I do know that from day one, Shoutcast would continue to be available. And building on what Mr. Parker referenced, when the public is attending live hearings, their view from where they sit is out the back of the applicants and the assessors. So they're not only not seeing documents that are introduced during the hearing, but they're not seeing the facial expressions at live hearings. They're just seeing the backs of the parties. And unlike the AAB, the public has no need to be assessing credibility and looking at people's faces. So I would concur with, well, Mr. Parker's indication that while AAB should certainly be free if their platforms enable it to broadcast the video of the hearings, that broadcasting audio of the hearings should suffice.
Thank you.
And when I say that, I mean to the public. I think the parties need to be able to see each other in the board.
Do we have
Brian
anybody else?
Rabowski on behalf,
Oh, sure, go ahead.
on behalf of CADA. Sorry, Chairman. Brian Rabowski here. Just to follow up on Mr. Parker and Ms. Berkman's comments, I think given the technological issues that have been raised, deleting the "and observe" from the last sentence would adequately cover not only the concern about having public access, but the technological issues that Mr. Parker and Ms. Berkman have raised. And I think CADA can support that revision. There are a few other revisions under this particular bullet, which is D sub-issue 4, that I would like to present on behalf of CADA. I'm happy to do that now, or I can wait until others have chimed in on Mr. Parker and Ms. Berkman's recommendation. What is your recommendation?
Let's wait and see if there's others on this adjustment or this little suggestion now, and then we'll come back to you.
Very good.
Mr. Chair, this is Don Gakel of the CAA. I think I appreciate and support the comments of Mr. Parker and Ms. Berkman, but I also want to not speak on their behalf, but I wanted to emphasize, I think they had a concern about the use of confidential documents as opposed to the word trade secrets, which is in the rules and statute in that second bullet. They can correct me if I'm wrong, but I think that was a issue they have with the language.
Anybody else?
This is Thomas Parker from Los Angeles. I will only say that I was assuming that confidential would be the equivalent of trade secret in response to the question raised by Mr. Gakel. Thank you.
Mr. Chair, hi, this is Malia. Can you hear me? I had to call in.
Oh, yes, go ahead. Member Cohen.
Okay, great. I just need some help in understanding something. I think the presenters and the folks on the call have addressed it, but my question is, how do we make sure that we achieve public access, even if it means observing? And this, of course, is without having access to confidential documents. And that question is not to any specific person, but to whoever can answer the question. Hello?
Hello, do we have anybody on the line that's able to address that?
This is Don Gakel with the CAA. I think just to follow up on that, having been a participant in lots of appeal hearings in the past, I think observe in the sense of even in-person hearings, as Mr. Parker said earlier, is that people are there to, they can hear what's being said, they can participate in the discussions of the documents. Generally speaking, they're not seeing the documents, but they are hearing the discussions that are taking place, and that the public being able to hear the discussion that's being taken place would give the same benefit that they generally have in in-person appeal hearing, which is to listen to the discussion and the arguments, as opposed to actually being able to see any documents.
Okay.
This is Thomas Parker. I would concur with Mr. Gakel. I would add, if you use by analogy a Board of Supervisors public hearing, the public does not have a right in the immediate moment to have all the documents in their hand when they're physically sitting in their seats observing the Board of Supervisors or a city council for that matter, conducting their public business. They can listen, they get to make public comment, and they can afterwards or through a Public Records Act request obtain documents. So the fundamental thing is that the public needs to be able to listen to what is going on and see, and they can decide if they agree or disagree with the official actions to be taken.
Mr. Chairman, this is Chris O'Neill. I've been listening, and I'm the chair of CADA. And addressing Ms. Cohen's question about observing, I would just make, I guess this would be an observation, and that is that the law, the statutory arrangement for assessment appeals boards only requires that an audio recording be maintained as the official record of the hearing. And that audio recording then is available to anybody, a member of the public or any of the parties. So it would seem that when the legislature set up the procedures for assessment appeals board hearings, they only had in mind that the public record would be an audio recording. That may in some way support what Mr. Parker has been saying about that an audio recording would be sufficient. And I think that's one reason why CADA would be willing to remove the observe language. And I would just also say in response to Ms. Cohen's point that it is true that a member of the public can sit in the boardroom and observe the proceedings, and that's more than just listening. But I think that I'm not sure that that's absolutely required based on the legislature's decision to make the official record of the proceeding an audio recording. That's all I have. Thank you, Mr. Chair.
Member Cohen, does that address your issue?
Yes, it does. Thank you.
Thank you. Any other partners out there?
This is Kathy McClellan with Sacramento County. I just wanted to say I fully concur with the last speaker. My thought was making it that it must be able to be observed was beyond what AAB is required as far as recording, because I knew it was just it was only required that an audio be recorded. And so I agree with the last speaker and feel like the "and observe" portion of that sentence should be struck. Thank you.
Thank you. Anyone else?
Chairman, I'm happy to go on. This is Brian Rabowski. Happy to go on to present CADA's other suggested revisions for this first bullet point.
Yes, go ahead.
Okay. So just working sentence by sentence in the existing language. In the first sentence, this is very minor, but we want to make sure that it's clear. Presently, it says direct cross-examination. We believe there should be an "and" inserted so that it's direct and cross-examination of witnesses. I think that that's consistent with the intent, but does have some change to the meaning, I suppose, in terms of clarifying. Moving on to the next sentence that begins, the board must also be able. Here we think there's a couple revisions to this sentence that's needed. As drafted, it's only focusing on the board members and the board's ability to view documents and hear parties. I think consistent with the discussions that the work group has had in the last several meetings, the idea is that all parties, in addition to the board, should be able to not only view the documents, but hear everyone in real time. And of course, that's needed for all participants to meaningfully be involved in the hearing. And so what we did was we've crafted some revisions to the second sentence, and I'll go ahead and read the sentence as Kata would suggest. Unless freely agreed otherwise by the parties, all board members and the parties must also be able to view all documents that have been introduced into evidence and hear all parties in real time in order to render its decision only on the basis of proper evidence presented at the hearing in compliance with Rule 302. And let me just add before I open this up to discussion for others, at the middle of that sentence, we've also specified that it's the viewing of documents that have been introduced into evidence. And I think this dovetails into some of the other statements we've made about information and evidence not being presented to the parties beforehand, even though we're submitting it to the clerk so that they can process and be ready for the hearing. So here we're specifying that you're only able to view the documents as they're introduced into evidence. And then finally, we suggest adding a third sentence. It would be a new sentence in full, and it would read, once introduced, the board members and parties must have the ability to view and download the full exhibit at their discretion, independent from the controlled screen display shown during the remote hearing. And again, this is an idea that the work group has discussed quite extensively. The concern is with the clerk presumably controlling the display of the document during the remote hearing. You're only seeing the portion of the screen that she's allowing you to see. And oftentimes documents are much larger than that, typically several pages long. So we think it's incredibly important that all participants be able to download that full document and to be able to review that document in full at their leisure, rather than just having to be focused on what the clerk is displaying. So this new sentence that we've added here is intended to address that concern. Thank you.
Thank you. Can we get some reaction or responses from AAB and the other partners?
Mr. Chair and members of the board, Thomas Parker from Los Angeles. Los Angeles does not have any objections to the proposed edits just discussed by Ms. Hrabowski.
Thank you.
Marcy Berkman, Santa Clara County. We concur with Kata's edits. And in the middle of the paragraph, it looks like a word or two needs to be added for grammatical reasons. So it would be, from where she's typed, all board members and the parties must be able to view all documents that have been introduced into evidence and hear all parties in real time in order. And I would suggest they're adding for the board before the words to render its decision.
Thank you. Anyone else?
This is Don Gakel of CAA. I have no issues with Kata's recommended changes, and I would support the amendment offered by Ms. Berkman.
Thank you.
This is Brian Hrabowski on behalf of Kata. Just for completeness, we agree with Ms. Berkman's suggestions to add those additional words.
Thank you.
This is Kathy from Sacramento County. I agree with Kata's edits and Ms. Berkman's suggested change.
Anyone else? Hearing nobody else, let me ask Ms. Evans, were we able to capture that?
Chair Vasquez, yes.
Yes.
I'm not sure, for the sake of the parties, do you want me to read what has been agreed to?
Sure, go ahead.
Basically, All parties must be able to present evidence, written and oral, as well as direct and cross-examination of witnesses, and document in real time at remote hearings per Rules 302, A, 1, and 313E, and RTC Section 1609 and 1610.2. Unless freely agreed otherwise by the parties, all board members and the parties must also be able to view all documents that have been introduced into evidence and hear all parties in real time in order for the board to render its decision only on the basis of proper evidence presented at the hearing in compliance with Rule 302. Once introduced, the board members and parties must have the ability to view and download the full exhibit at their discretion, independent from the control screen display shown during the remote hearing. Additionally, the public must be able to hear the remote hearing as required by RTC Section 1605.4.
Thank you. That was pretty good.
That's the agreed upon language as I captured it.
This is Thomas Parker of Los Angeles. You captured it.
Thank you.
This is Don Gakel of the CAA. Yes, I agree. You captured it.
Brianne Rabowski on behalf of CADA, I agree.
Marcy Berkman, I agree.
Kathy McClellan, I agree.
Thank you all. Let me just double check with Ms. Taylor if we have any written comments first.
Chairman, we do not have any written comments.
You want to check with AT&T and see if there's anybody on the public line?
I will. AT&T moderator, do we have any public comments on this matter?
Once again, if you'd like to make public comment on this matter, you may place yourself into the queue by pressing 1, then 0 on your telephone keypad. And there is no one queuing up at this time.
Thank you. Let me turn to the members. Any comments or questions from any of our members? Seeing and hearing none, we will go on and move on to the next item. Ms. Davis, I believe now we're on the 5th non-consensus sub-issue, which is issue C. Oh, I'm sorry. Is Ms. Stowers joining us?
Yes, I just wanted to let you know I have joined. I'm sorry for the delay. I was double booked, but I was watching it on the webcam.
Thank you. Welcome.
Okay.
With that, let me have Ms. Taylor go on to our 5th non-consensus sub-issue, issue C.
Thank you. Our 5th non-consensus sub-issue is issue C, technology options, sub-issue 4, investment in remote hearing capability, efficiencies realized long-term. The suggested statements are, first bullet, counties already conducting remote AAB hearings are encouraged to continue to protect their investment, perfect their system, troubleshoot issues, and train staff. Counties not yet conducting remote AAB hearings have flexibility to continue to conduct in-person hearings subject to their respective health and safety protocols and may develop future long-term contingency plans for efficiently utilizing technology to conduct remote hearings as appropriate. Sub-bullet, contingency plans suggested for enhancing efficiencies in counties utilizing remote hearings may include, but are not limited to, establish recessing procedures to troubleshoot issues, provide IT assistance prior to and during the hearings, provide contact information, phone numbers to contact parties and AAB members in the event of technical difficulties, establish continuance procedures in the event that a technological problem cannot be resolved. Sub-bullet. Additionally, AABs should be sensitive to failures to appear at a scheduled hearing due to a party's technical difficulties. Sub-bullet. The greatest efficiencies of long-term utilization may be realized for procedural matters, parentheses, postponement requests, reading in stipulations / recommendations, pre-hearing conferences, etc., parentheses, and for low-value property hearings with few documents. And that concludes.
Thank you. Can we have members representing the AABs please address the sub-issue C4?
This is Thomas Parker from Los Angeles, chairman and members of the board. We have no, Los Angeles certainly has no issues with the proposed language.
Thank you.
This is Brianne Rabowski on behalf of CADA. CADA does have one recommended change, and it relates to just one of the existing bullet points. It's the second major sub-bullet point. It currently reads, additionally, AAB should be sensitive to failures to appear at a scheduled hearing due to parties' technological difficulties. And here our concern is that the word sensitive isn't strong enough. Our opinion is if it's affirmatively known that there's a technological difficulty that stopped a participant from appearing, that affirmatively should not result in a denial of the appeal. And so here we've provided suggested revisions to the language. The language that we suggest reads as follows. Additionally, AABs should not deny assessment appeal applications if a party's failure to appear at a scheduled hearing is due to technological difficulties. And there is one sort of point of clarification that's worth considering, which is at the time that a party would not appear, if it were due to technological issues, it is very possible that the board wouldn't know that it was the technological issue that stopped that particular party from appearing. All the board would know is that the party didn't appear. And in that instance, you could see it being logical that the board would deny the appeal because they don't know why the participant didn't appear. And so really what this is saying what would happen in that instance is there would be a request to reopen the appeal, a request to reconsider that denial. So this is really directed at telling boards that it's inappropriate once it becomes known that there's a technological issue to deny that appeal. And so we believe our suggested language adequately covers that concern.
This is Marcy Berkman, Santa Clara County. I concur with the board's original language, and I disagree with CADA's proposed revision. As Ms. Rabowski was discussing, if somebody is having trouble connecting and they contact the clerk during the hearing before it ends to let them know, then the board is aware of the technological difficulties, that they can't connect because the internet is down or they can't make the hearing platform work. And then, of course, the board would be sensitive and not deny for lack of appearance. But there may be a situation where the party just doesn't show up and they don't contact the clerk, either because they're too frustrated, busy trying to connect, or they don't remember to call the clerk, or maybe the phone lines are completely down in their neighborhood, or whatever. So what happens is if somebody just doesn't show up and doesn't contact the clerk during the hearing, is the board has no idea why the person hasn't shown. And given the vast majority of people who tend to no-show at hearings on a regular basis, the logical assumption is they just didn't show. If the reason was that they had technological problems connecting, then what's going to happen is they're going to file the form for a request for reinstatement from the denial for lack of appearance saying, I tried to appear, but I had problems connecting. Please reinstate me. And the board, of course, will reinstate. And I think that the board's original language captures that, but CADA's revision does not, because CADA's revision would serve as a prohibition on denying for lack of appearance, and would therefore, you would end up with situations where the board denied for lack of appearance with no idea that the reason the person didn't show up was because of technological issues. And you'd be in the reinstatement process, but you'd end up in a circumstance where the board unwittingly violated the SBE's guidance. And I think that for that reason, the SBE's original language appropriately covers the situation.
This is Thomas Parker from Los Angeles. I very much agree with what Ms. Berkman has just said. I can tell you that in Los Angeles, it's almost never do we deny a request that's made timely for reinstatement under Rule 326 of the State Board. So all they got to do is make a timely request, and they say, I had connectivity problems, whatever, and it'll be reinstated.
This is Brian Rabowski on behalf of CADA. I certainly appreciate the concerns that Ms. Berkman has shared, and I recognize that in the bulk of counties, the board would acknowledge the technological difficulties and reinstate the appeal. I do, however, have concerns given past situations. There are certain boards that are not keen on reinstating appeals once they've been denied for lack of appearance or denied really for any other procedural issue. So I'm wondering if maybe we can cover the concern that CADA has, which is making an affirmative statement that to the extent that it's technological difficulties that stand in the way, there shouldn't be a final denial of that appeal. If we can achieve that while also taking into account the very good comments that Ms. Berkman has made. And my suggestion would be that maybe we alter the language to say, additionally, AAB should not deny a request for reinstatement following a denial of an assessment appeal if a party's failure to appear at a scheduled hearing is due to technological difficulties. And so it's the same language that I read. It's simply saying that it's adding the idea you should not deny a request for reinstatement, because as Ms. Berkman has explained, from a procedural standpoint, that's the most likely way that a request would come in. It would come in after the fact. And I'm wondering if we adopt those revised, that revised language, if that would be acceptable to Ms. Berkman and others.
Ms. Dombrowski, this is Regina Evans. Can I get you to reread the language you're proposing?
Sure. Do you have the CADA language unrevised in front of you?
I do.
Okay. So it would just be where it says the AAB should not deny. You'd be adding a request for reinstatement. If the assessment appeal was denied due to a party's failure to appear. And it would continue on as suggested.
This is Thomas Parker from Los Angeles. I can accept the latest proposed CADA amendment that has just been read by Ms. Rabowski.
Mr. Chairman, this is John McKibben from CACEO. If I can just make another further suggestion. Is that possible?
Yes, welcome.
Thank you. I would ask the folks all the parties to consider adding a timely request for reinstatement, as was alluded to, I think, in Marcy's testimony.
This is Marcy. I would concur with Brienne's latest suggestion as modified by Mr. McKibben, that it be a timely request. Just for clarification, for the board's understanding, the Revenue and Taxation Code and property tax rules require that the request be made within 60 days or such shorter time period as the Board of Supervisors has adopted for their county. And just as an FYI, in Santa Clara County, we use the 60 days, although I know some other counties do have a shorter time period for their reinstatement request.
This is Tom Parker from Los Angeles. I concur with Mr. McKibben and with Ms. Berkman.
This is Don Gakel of the CAA. If the CAA CEO is fine with the change, as most recently amended by Mr. McKibben, we have no issue with that.
And Brianne Rabowski, again, on behalf of CADA, just to close the loop, we would of course agree with the addition of the timely request for reinstatement. Thank you.
Thank you. Is there anybody else? Any other partners? Hearing none. Let me just double check if there's any written comments. Ms. Taylor?
Chairman, there are no written comments on this item.
Can you please check with AT&T for any public out there?
Certainly. AT&T moderator, do we have any public comments on this matter?
If you make public comment at this time, you may press 1, then 0 on your telephone keypad. There is one keying up at this time.
I'm sorry, did you say there was one or is no one?
There is.
You got cut off.
There is no one in.
I think I heard no one. You're kind of breaking up, but I think you said no one.
That is correct.
Okay, thank you. With that, let me go back to Ms. Evans. I think we got it all, but let me, if you could please kind of capture the consensus here for us, I'd appreciate it.
Chair Vasquez, I'm not sure if I captured this properly, but I will read what I have written, and if amendments are needed, parties, please offer them.
Thank you.
CADA's language as proposed with amendments. Additionally, AAB should not deny a timely request for reinstatement if the assessment appeal application was denied due to a party's technical difficulties. Work group members?
Is that accurate? I'm waiting to hear.
Brianne Rabowski on behalf of CADA. I believe that covers it, yes.
Thank you.
Thomas Parker from Los Angeles County. Yes, that covers it.
Thank you.
Don Gakel, CAA. Yes, I agree.
John McKibben, CACEO, I agree.
Marcy Berkman, Santa Clara County, I agree.
Kathy McClellan, Sacramento, I agree.
Thank you. Looks like we have a consensus.
Vasquez,
Oh, I'm sorry. Go ahead.
for purposes of making sure we're all on the same page with our consensus, are we now stating for sub-issue 4, with that amendment, everyone else is comfortable with the language as proposed?
Yes. The only thing I was going to say is, now that we have a consensus on this one, I was going to ask if we can go back, because I don't want to assume, but I think there was consensus on the second paragraph going back to the sub-issue B4. You know, right now, earlier you read off, there was changes on that first bullet, but the second one that begins with technical platforms for remote hearings, I don't know if we officially, if people were comfortable with the way it was read into the record, or if there was any changes on that.
This is Thomas Parker from Los Angeles. You did catch a good point, Mr. Chairman. I wasn't sure if that was actually addressed explicitly or not in that part of the discussion. So I think it is appropriate just to nail that down now. And the language as proposed by the chairman's letter is acceptable to Los Angeles. Thank you.
Thank you.
Brianne
Anybody
Rabowski
else?
on behalf of CATA.
Yes.
CATA is in agreement as well.
Thank you.
This is Don Gakel, CAA. Yes, we're in agreement.
Thank you.
John McKibben for CACEO. I'm hoping I'm not beating a dead horse here with regard to the term confidential documents. If it's assumed that we're talking about documents with trade secrets, yes, we're comfortable.
Thank you.
This is Richard Moon from the legal department. If I could just make a quick comment.
Sure.
With regard to Mr. McKibben's comment, my suggestion would be that we actually use the words trade secret rather than confidential documents, because although it's likely that the term confidential documents would be interpreted that way, using the actual words trade secret ties it directly to the existing rule.
Is everybody comfortable with that?
Question, if I could, Member Vasquez, this is Member
Yes,
Gaines.
Member Gaines, go ahead.
Yeah, on this question of confidential, could that include personal data that is critical? So, I mean, could it include a tax ID number? Could it include a social security number? Something beyond trade secrets that you would still want kept confidential? And in fact, if there was a breach of that data, that would create a lot of anguish to that party.
This is Marcy Berkman, Santa Clara County. Firstly, the things that are closed from hearings and required to be sealed are trade secret only. Secondly, appeals boards and appeals clerks are very sensitive to watching for the types of things that you talk about, individual social security numbers, or occasionally someone will submit very detailed medical information as an explanation for why they did something. And the clerks and the boards are very careful about watching for that when it comes in, and suggestion to the parties, let us hand that back to you and not have it submitted as an exhibit, or will you please redact it before you turn it in, so that those things never become part of the public record.
Okay, thanks for that clarification. I am curious, and Ms. Berkman, maybe you could help clarify it for me. If there were a breach of data that was confidential and personal in nature, what would be the process for an individual that had, that had presented information, for some reason, maybe it wasn't redacted before it was presented? Is there a recourse for that constituent through the county?
This is Marcy Berkman. In 20 years of doing this, I've only seen that happen once. And what happened in that situation was the applicant had attached, I believe it was some detailed medical information to their assessment appeals application, to which they're not supposed to attach anything. And what I had the clerk in my county do is they put that in a sealed file, marked sealed confidential medical information, so that would not be publicly accessible.
Okay, so it sounds like the risk is not that great. It just sounds like it's something that really doesn't happen.
That's correct. And because the nature of it is the evidence that's being submitted at appeals hearings is comparable sales values of, properties in the neighborhood taken from publicly available information, income stream data taken, from CoStar, and other types of things in the nature of the hearings. The one area where hearings are closed and information is sealed is very limited to documents and testimony strictly related to trade secret. And the law requires that only that portion of the hearing is sealed and closed to the public, and that all other parts of the hearing and all other evidence is public.
Okay, that's great. Thank you. I appreciate it.
And this is Thomas Parker from Los Angeles. In Los Angeles, when we have trade secret information and testimony, we create a separate sub-file for that part of the appeal documentation. And if we get a Public Records Act request, we don't release that trade secret testimony and documentation. And we create that separate sub-file so we don't inadvertently give that out when we're responding to a Public Records Act request.
That's great. Thank you, Mr. Parker.
Mr. Chairman, and Senator Gaines, John McKibben on behalf of CA CEO. Assessment appeal records are also covered by the California Public Records Act, as are all other public agencies in California, and there are very extensive exemptions to what can be disclosed as a public record. So the clerks are governed by that. They're very well aware of it, and they're very careful to not release information that they know to be confidential. Oftentimes, though, it does take the member of the public whose record it is, needs that person to come forward and make sure that the clerk is aware that this document contains a non-disclosable piece of information under the Public Records Act.
That's great. Thank you.
Member Gaines.
Yes.
Member Gaines. This is Chris O'Neill, Chairman of CADA. I would agree with Ms. Berkman that as far as the property tax statutes and property tax rules are concerned, we do focus on what is a trade secret. And in fact, California has adopted the standards for a trade secret from the Uniform Trade Secrets Act, which are incorporated by reference into the property tax rule and I believe the statute. That being said, that doesn't obviate the fact that the California Constitution establishes a right of privacy, for example, and that there are other statutory privacy standards, both at the federal law level and on the state law level, and those wouldn't go away here. But I think, as Mr. McKibben has said, that impacted person or that affected person would have to stand up and say, but those are my medical records. No, those can't come in, or this is private data of some sort that's protected by federal law or state law in other ways by other statutes. So we're not saying that kind of information could somehow come in and would have to stay in. Those other protections don't disappear.
That's great.
But for our purposes, for our purposes, we live, as Ms. Berkman says, we live in the, is this a trade secret or is this not a trade secret world? That's our world for property tax purposes, really.
Wonderful. Thank you.
That's all I've got.
Thank you, Chair Vasquez.
Thank you. Any other comments from any of the members? Hearing and seeing none, let me ask Ms. Taylor if there's any written comments on this item.
There are no additional written comments on this item.
Can you please check with AT&T for anybody on the public line?
Yes. AT&T moderator, do we have any public comments on this matter?
If you would like to put yourself into queue for public comments, you may press 0 on your telephone keypad. No one is queuing up on telephony.
Thank you. Ms. Taylor, is the way I see it, I think that concludes all the items of the non-consensus items, correct?
I would agree.
Thank you. Let me just say, members, once again, this concludes all the items on the non-consensus items. Each consensus statement approved will be placed in an LTA by the executive director. The remaining unresolved items will be addressed at the meeting in December. This time is set aside for input on 3 new sub-issues. The board's current guidance on these items is the AAB manual and the rules quoted in the November 3rd memo. Please let us know in your comments whether our current guidance should be changed to accommodate remote hearings or some other action be taken. Based on this, we will develop some possible recommendations to bring back to the board next month. When you're called upon, please briefly address all 3 sub-issues. First, developing efficiencies around scheduling and scheduling mechanisms. For example, does the current information in the AAB manual, page 36, on scheduling hearings need to be revised for remote hearings? Second, establishing a meeting and confer process. For example, since we don't have a meet and confer process in the AAB manual, should we refer to as the assessors to see they would be willing to work on it? And third, offering pre-hearing conferences. For example, since current law authorizes county boards of supervisors to adopt pre-hearing conferences and establish the procedures, do they all already have authority to adopt this law to remote hearings if they choose to?
Mr.
With
Chair.
that, I'm sorry, I'm hearing somebody, is that one of the members or is that Ms. Cohen?
Yes, Mr. Chair, it's me, Malia Cohen.
Yes, go ahead.
Good afternoon. I was wondering if it's 12 o'clock, if I could request for a 10-minute, very, very brief break after you finish your reading, but if we could take a 10-minute break, I would appreciate it. Hello? Hello? Hello?
Or excuse me, I guess I was muted. I'm sorry.
Oh, okay.
I was going to just say that actually concludes my the 3 that I was going to present and ask for a response from our partners. And if the members are okay with it, we could take a quick 10-minute break.
Yeah, just quick.
Yeah, that's fine. I would appreciate that too. Thank you.
All right, why don't we go ahead and take a 10-minute break? It's I have 12:02, I think. So why don't we say 12:15, we'll reconvene.
Thank you so much. Okay.
Thank you.
13-minute break?
15 minutes. finishing off reading the 3 brief sub-issues. And I wanted to see if I can get some response from our partners, starting with the AABs, if they're on the line.
This is Thomas Parker from Los Angeles. I just wish to make sure I understand, Mr. Chairman and board members. You would like comments on all of the issues, or are you going to go issue by issue?
I read off the 3. That's what the sub-issues. You know, the first one was developing efficiencies around scheduling. Did you want to address each one first?
I certainly can, sir, and members of the board. And before I do that, I wish to apologize to Member Cohen. Earlier on in this meeting, I addressed her by her first name. I thought there was someone else other than Member Cohen who was being referred to. So, Ms. Cohen, I wish to apologize for addressing you by your first name. You know, in a public meeting. That was not appropriate, and I do apologize.
Apology accepted. Thank you.
First of all, new sub-issue 1, as far as scheduling and scheduling mechanisms go, this sub-issue is really best left to each local assessment appeals board to determine based on its resources, workloads, and needs, what efficiencies work best and what efficiencies do not work. As the CEO in Los Angeles have previously noted in developing the consensus statements, the state board can serve as a clearinghouse for possible ways of handling procedural aspects of appeals. But ultimately, the county AAB must be allowed to control its own calendar as a constitutional quasi-judicial administrative body. The meet and confer process. This is a tricky one. Meet and confer processes in normal civil litigation involve not just procedural issues, but what I will call substantive issues. Substantive issues that sometimes lead to resolution, sometimes they don't, but they can easily fall into contexts where evidence of both parties is discussed and essentially introduced in advance. This creates a problem for AABs because meet and confers, if they get into those substantive issues, are introducing evidence to AAB members where AAB members are involved before the hearing on the merits have started. And that clearly is not allowed by property tax law and regulations. It leads to a possibility of an AAB, if there is no resolution at the meet and confer session, it could lead to AABs prejudging the appeal, either for the applicant or for the assessor. And that's not good and that's not allowed. So that we have concerns about the meet and confer process. Pre-hearing conferences under Property Tax Rule 305.2 are already allowed. They've been allowed for many years. Where pre-hearing conferences are appropriate, given the workload and the resources of any given assessment appeals board, they can be very useful things on procedural issues only. And that's what they're designed to be. We do not believe that pre-hearing conferences should be mandated. They should be allowed as an additional tool as currently is envisioned and put down in Rule 305.2. Los Angeles County in particular, we have so many appeals as it is that we need to be careful about where and when we use pre-hearing conferences. Los Angeles currently uses pre-hearing conferences largely when parties request them, or very, very occasionally when there are procedural issues that the panel wants to address. But we do not mandate them in Los Angeles. And because of our workload and limited hearing time for all of our panels per year, we have to be very careful about that as a practical matter. Thank you.
Thank you. Before we keep going here, can I just take a pause here for a minute and ask AT&T? I understand Ms. Evans has been on hold. Can we make sure she gets in on our call here? Ms. Evans, are you on the call? Is the AT&T operator available?
Yes, I'm here. Who are you looking for at this time?
Regina Evans. Can we allow her in?
One moment. Ms. Evans appears to be self-muted. She is not in broadcast mode at this time on our end.
Ms. Evans, can you hear me?
It looks like she's dropped off. She may be dialing back in.
Oh. Vice Chair Schaefer here.
Yes, Vice Chair Schaefer.
We're dealing now with page 6, 7, and 8 of the material presented to us. You've just discussed items 1, 2, and 3. I'd like to start off with my comment that page 6 is called page 6 of 2. I don't understand that. There's 11 pages, not 2 pages. Wouldn't that?
You know, Mr. Schaefer, yours seems to be numbered different than mine, so you might want to check with your staff on that.
Okay, that's thank you, Chair. My next comment is.
I think he must be looking at Kata's letter, which is numbered that way.
Yeah, Kata's.
You might be looking at Kata's letter.
Yes.
Okay, I'm looking at Kata's letter. But we're discussing the items on Kata's letter. The red type here, the increase in Proposition 8 assessment appeals expected. I would put a period after expected.
We're on page 6 now.
On page 6 of 2. Instead of go on to, quote, for tax year 2020 and -21. Well, you know, 2020-21 is going to be stale within 12 months. I don't think it's necessary to date that, because if we adopt the language 2020-21 now, it's all going to be out of date in 12 months. I think we could eliminate the 5 words there and put a period after the word expected, and it wouldn't change the meaning at all, and it would avoid it from being stale when the clock turns a few times. That's my comment. Thank you.
Okay, Vice, let me double check here. Do we have Ms. Evans on the line now?
Chair Vasquez, I'm on the line. Thank you.
Oh, okay. Sorry about that. Okay. So,
Chairman, this is Brian Rabowski on behalf of CATA. I just wanted to address Member Schaefer's comments and then perhaps present on these 3 items, if that's okay.
yes, go ahead.
Okay. So first, I have to sincerely apologize. Member Schaefer has hit on 2 typos, and we were working very quickly to respond to the chairman's memo dated November 3rd, which we received last Friday. And so I sincerely apologize for these somewhat embarrassing typos. You are correct. The page number 6 should be not of 2, but of 12. So I apologize for any confusion that has caused. And with respect to the language that is redlined here at the top of page 6, the reference should actually be to tax year 2021-22, so the upcoming fiscal year rather than the present fiscal year. And the reason is that given the upcoming lien date, which is upon us just very quickly here on January 1st of 2021 for the new upcoming tax year, there is an expectation not only among practitioners and taxpayers and clerks and board members and assessors, I think everybody's in agreement that there is likely to be an avalanche of appeals that are filed on a Prop 8 basis, and that's a decline in value basis, on an argument that the values of properties have substantially declined due to COVID. And we may or may not agree collectively, you know, whether or not to the extent that that's occurred. But in any event, I think people do agree that there are likely to be a huge number of appeals filed here in the near term. And so I think it is important to note that the intent of these additional items are really to try and work on the efficiencies at the board level and how we deal with the backlog of some counties. Not all counties are backlogged, but many of the larger counties and those with substantial number of appeals that are filed each year were backlogged well before COVID-19 hit and will continue to be backlogged. And that will only worsen against the backdrop of the Prop 8 decline in values that are expected. So CATA raised these three ideas as ways that we could come together as a group, as a working group, either the existing working group or a follow-on work group, to really brainstorm how best to address that backlog. And we think, of course, it's in everybody's best interest that we work through those backlogs. And so the two things that we really identified as avenues to do so were, one, working on scheduling and making sure scheduling is as efficient as possible, and two, working on pre-hearing resolutions. And so in the vast majority of cases, appeals are resolved amicably, and that's either through stipulations or value recommendations, because the two sides have come together and agree that the value should be changed according to their recommendation or stipulation, or alternatively because of withdrawals. After, you know, in many instances, after a taxpayer has sat down with the assessor and understands their valuation perspective, they'll decide to actually withdraw those appeals. So in a number of instances, a full-blown hearing isn't needed. And so the intent of our recommendations is to cause the parties to come together much more earlier than they normally do. So in the ordinary course of events, in most counties, especially large counties, the parties will not talk about the case. They won't talk about, you know, valuation perspectives or their evidence with one another until a hearing is scheduled. And that causes a number of concerns, and I understand it causes concerns on both sides. It causes concerns not only for the assessor, who have taxpayers that at times aren't coming to the table when they should be before a hearing is scheduled. And from CATA's perspective, we have instances where we're pounding down the assessor's door ready to talk about things, and we aren't prioritized until a hearing is scheduled. So to alleviate these problems, we thought of two sort of ways to address this. And the first is the meet and confer process that Mr. Parker was referring to. And I think there's a couple things to clarify here. So from CATA's perspective, we recognize and agree that the board members should not be involved in terms of actually participating or being made party to the meet and confer process. What we're recommending is a new process that is not mandated, so there is no requirement that a county adopts this process, but rather it would be laid out in a new rule by the board or laid out in an LTA alternatively, and encouraged for counties to encourage the parties to engage in this process. And that would be a private meeting between the parties. The board member is not involved. The topics that we recommend that they discuss are the topics included in the pre-hearing conference rule, which is Rule 305.2A. Those, as Mr. Parker stated, really cover procedural issues. And we think that's an important first piece of what needs to be discussed. But additionally, in the meet and confer process that's private, we would encourage the parties to start talking about potential resolution, either of the entire case or simply narrowing issues, so that if a hearing is needed, you have a narrower set of issues that require board time and require board resolution. And so we recommend that those two things be considered together. And then for purposes of communicating that information to the clerk and making sure that it's fully understood, we thought that the process of having a BOE prescribed form that could be used by counties would be helpful. And what that form would do, and I won't walk you through the details, but what that form would do essentially is at a very high level, report back to the clerk. This meeting has occurred. It occurred on this date. We came up with a resolution or did not. We have these high level issues that are left. And then to wrap back in the scheduling efficiencies, what we would recommend is that the parties then list, we think we need X number of days of hearing, you know, couple hours, whether it's 2 or 3 days, it's contemporaneous, day after day, rather than big continuances in between. And we are available and our witnesses are available on these and these days or unavailable on these and these days. And what that'll allow the clerk to do is then take and process that information. So you're effectively getting the benefits of a pre-hearing without having to take board time to do that. You have a clerk in a position where they understand the case and the hearing days that are needed, and they understand from both sides when the parties are available for that hearing. And for us, that's really critical because you're not wasting board time by scheduling hearings on dates that are going to have to be postponed because a witness or a party isn't available. So we think this really resolves some of the inefficiencies that we're seeing in scheduling currently, where the taxpayer isn't able to check beforehand whether or not folks are available on a hearing date. We simply get a notice of a hearing date that, from our perspective at times, falls out of the sky. So I think there's a lot to be done there. Finally, on the pre-hearing conference front, of course, there is the existing rule. We think that rule is used very well by certain counties. I think Santa Clara County, where Marcy Berkman is county counsel to the board, Santa Clara uses it very well to get through procedural issues, and I think it's very effective. So here, rather than doing something new, what we'd be asking is that the board encourage counties to use and adopt this rule to facilitate not only scheduling, but also procedural issues that come up. And again, that would be on the existing platform. So those are our preliminary ideas, but our request really at this time to the board is, we've had such a fantastic experience working as a work group on the issue of remote hearings. We request that the board continue a work group on these new topics to brainstorm these 3 items that have been identified and to really talk as a group that's heavily invested in the efficiencies of the board. How do we get through the backlog? How do we brace ourselves for the onslaught of appeals that are coming? And how do we work together in a way that's best suited to achieve that? Thank you, board.
I appreciate your comments and especially the way you were concise in wrapping this thing up. Let me see if, is Don Gecko on the line as well right now?
Yes, Chair Vasquez. I'm here. Well, I'll just 3 issues. Develop efficiencies around scheduling and scheduling mechanisms. Certainly have no issue with that. Other than that's really an AAB issue. I appreciate the statement that was made in your letter that this is a local AAB issue to determine, and AAB must be allowed to have control over that. That being said, you referenced and I think Kata referenced the Assessment Appeals Handbook, and certainly that instructions on page 36 of that handbook should probably be updated given the LTA that's already issued today regarding authority to conduct remote hearings and rights of hearing participants. I guess I would have to say when I had trouble understanding the meet and confer process that was discussed by Kata. I think I can speak for the vast majority of assessors in the state. Probably do not have backlogs, and certainly when we've had high volume of appeals, We do get them scheduled. Often, even under the best of circumstances, appeals are often scheduled a year after filing. And I guess I would have to say, as far as meet and confer, that's kind of a process we use right now. We're certainly open to, and I think most assessors are open to getting information. When I say that appeals are often scheduled a year after they're filed, just for practical, fitting them into hearings and that sort of thing. Unfortunately, in a majority of cases, we haven't received any information from appellants by the time those are scheduled for hearing. In some cases we have, and we always appreciate getting information up front from appellants. I was interesting to Ms. Hrabowski's comment about beating down the doors. I only wish that our door was being beaten down by appellants with information that we could resolve. Certainly that's what we try to do. We, of course, even on our tax bills, we recommend that appellants, if they have questions, call the assessor's office. Overwhelming majority of our appeals are resolved either through withdrawal or stipulation. And to me, that's the meet and confer process that we try and engage in all the way along. Sometimes it's difficult to get information. Relatively small percentage of our hearings go to or our appeals go to an actual hearing. And so, and I think that's probably true of the vast majority of counties in the state. I know that there are some major issues in large counties, and I suspect that that's where most of these comments are going. But I guess I don't necessarily understand the meet and confer process as it relates to vast majority of assessors in the state, which we're doing that all the time now. Pre-hearing conferences are actually something that our county has not done really before, but our board is working on rules for that right now. And so I think that's well established. And some of the things that Ms. Hrabowski was talking about in terms of the meet and confer process sounded like they really belong more properly to the pre-hearing conference venue. So those would be my comments.
This is Brian Hrabowski from CADA. If I might just respond to some of those, if that's okay.
Sure, go ahead.
So to clarify on the meet and confer process, and I think Mr. Gakel brings up some really good points of perspective from the assessor's side. We certainly recognize that there are taxpayers that are unwilling to come to or don't come to the table before hearing. Perhaps my comments on pounding down the door are personal comments, as I tend to try and get ahead of things before hearing, but I know I'm not the only one. I know there are others that try to do the same, and at times it falls on deaf ears. But my point really is that what we have here are both sides of the table, if you will, saying the idea of coming together well in advance before a hearing is scheduled or imminent, and exchanging information informally, not a formal exchange, exchanging, information to the extent appropriate, talking about the case to see if a resolution can be met, is something that everybody recognizes desired and mutually beneficial. So if the board were to create and outline this meet and confer process where you're encouraging but not requiring, encouraging parties to come together privately to talk about these things, here's a way that I would envision it would directly address and help the situation that Mr. Geickel identified, where he was saying that they wish that people would come to them beforehand with evidence. It could involve, we have the procedure that's outlined by the board. A clerk could send information back to a taxpayer showing them there is a meet and confer process. We encourage you to use it. Or alternatively, an assessor could send out, much like a 441D, but could send out a notice saying, we have this procedure. We'd like to talk with you about this. Please contact us at this number to schedule your meet and confer discussion. Again, these aren't things that I'm saying are mandated, but oftentimes you have folks that don't come forward before pre-hearing because they don't understand or don't quite get how to engage in the process. So I think that this will provide a heavily beneficial tool to both sides to be used that will deal with some of the concerns and really elevate pre-hearing resolution of cases. And on the pre-hearing conference side, Mr. Gakel suggested that many of the things that I was saying would be discussed during a meet and confer process were better suited for a pre-hearing conference. However, the concern from CADA's perspective is that pre-hearing conferences aren't often used by many counties. There certainly are some that do use them. We've talked about Santa Clara, San Mateo is another, but they aren't used to their fullest extent. And my understanding as to why that is because neither the clerk nor the board have the time to schedule those and set aside time for a pre-hearing distinct from an evidentiary hearing. And so the meet and confer process is designed to take the benefits of the pre-hearing conference and really remove that from the shoulders of the board and the clerk and encourage the parties to talk about these things so that you're not wasting board and clerk time, but you're still getting the benefits that everybody's seeing when pre-hearing conferences are used. So we'd encourage the discussion to continue around these items to see how the parties can come together and where we can have a meeting of a mind on how we would work through some of these ideas. Thank you.
Thank you. Any other
Marcy
partners?
Berkman, Santa
Oh,
Clara
yes, go ahead.
County.
Go ahead.
And I'd like to address the 3 topics in reverse order, just because that's logically how my brain works. For pre-hearing conferences in Santa Clara County, we make them available anytime either the applicant, the board, the clerk, or the assessor wants to set them so that they are available. People tend to only use them when they're going to need to push hearings out or have a special set hearing. Or, for example, say, we'd like you not to set us right now because there's a 4-year audit going on that we think will resolve most of the issues. So can you please set us for another pre-hearing conference in 5 months? And so, as Brianne mentioned, they worked very effectively in Santa Clara County, and they're on an as-needed basis. My suggestion for pre-hearing conferences would be for the state board just to send an LTA out reminding counties of the availability and the way they can be used and encourage them to consider using them, and nothing more than that. As far as the meet and confer process goes, meet and confer has a term to those of us who are civil litigators that you're required by law to do something and then you have to turn in a paper to the court to prove that you've done it. In Santa Clara County, we are all for encouraging the assessor and the applicant to talk early and often in an effort to sort things out and resolve things. But my belief is that needs to stay strictly between the applicant and the assessor, and that it is better called an informal meeting because of the civil litigation context of meet and confer. And also, I would suggest that while we completely believe assessors and applicants should speak to each other early and often, the clerk needs to be left out of that, as do the boards. If you're looking at, for example, a county with 15,000 cases a year being filed, that's 15,000 additional meet and confer statements, which may be 1 page or more pages more, that need to come into the clerk, be opened, be processed, be scanned into our digital systems, and be dealt with in some way. And that in itself will create a backlog and a huge excess at work at a time when counties are beginning to lay off people because of the budget crisis. And don't have enough money for their operations as is. And we certainly don't want to be adding to the stress and the backlog by creating additional unnecessary paperwork. But I am all for encouraging applicants and assessors to meet early and often. One thing we in Santa Clara County frequently see is that the assessor will issue 441D letters early on in the appeal to get the information that they need in order to begin informal resolution discussions with the applicant. And one thing we constantly see them complaining at before the board is that applicants, and especially those who are represented by tax agents and attorneys, but especially tax agents, tend not to respond to the 441D letters until a hearing date is actually set. And then what happens is they don't respond to the 441D letters, and they end up on our very long noncompliance calendar, which on some days is by far the most number of items on our calendar. And then what happens, invariably in 99% of them, the tax agent appears for like 60 items and says, yes, we received the letter, or I've seen this letter before. It's a standard letter. I'm sure my client got it. I don't see any reason why we can't produce it. We'll turn it over in 60 days. And so systematically, the tax agents and attorneys are sitting on the 441D letters from the assessor until after a hearing date is set, and indeed until after that hearing date turns into a 441D noncompliance hearing. So in terms of getting things scheduled and decreasing the backlog, I would suggest that the board send out an LTA reminding applicants and agents and attorneys of their duty to timely respond to an LTA rather than waiting till the last moment before a hearing or even longer to turn over that information, so that the parties can start that process of informally working together. Because when an appeal is filed, the assessor doesn't even know what the applicant's issues are until the applicant responds to the attempts to reach out via 441D letters and other things. And in our county, what I constantly hear is, occasionally we'll hear from a self-represented applicant, hey, I would have liked to meet, and I didn't. But far more often what we hear is the assessor complaining that applicants, especially those represented by tax agents, don't respond to the 441D letter right up until the hearing date, and sometimes till after that, causing the hearing date to have to be pushed. Another issue that causes problems with scheduling hearings and backlogs is very frequently taxpayers, and especially those who are represented by agents, attorneys, or sophisticated tax departments within their corporation, will file protective appeals. And 6 months, a year might go by before they even take a honest look at it to see whether they really have an issue, but they didn't want to blow the filing deadline. And frequently from the board perspective, what we see is that cases are first being withdrawn days before the hearing, and sometimes on the hearing day itself. And in fact, in Santa Clara County, we often see the withdrawals come in so late that following the hearing, there'll be requests from agents to turn denials for lack of appearance into withdrawals because they first sent their withdrawal after the hearing started for the morning, and the clerks were downstairs at the hearing rather than upstairs where the withdrawal slip came in. And when agents and applicants first withdraw their protective appeals at the last moment, or 10 or 15 or 20 days before hearing even, that does not give the clerk time to backfill with additional cases. That if they had more timely looked and seen whether they really have an issue, the clerk would have been able to line up additional cases and slot them in. So we might start out with 200 cases on the calendar and end up with 6 go cases because of people who don't appear, or they don't return the response form, or the agents and attorneys and tax departments withdraw the application 2-3 days before the hearing. And so if the board can strongly encourage agents, applicants, tax departments to look at their appeals and decide whether they want to withdraw them much farther before the hearing, that would allow the clerks to more efficiently schedule a full calendar given the hearing notice requirements. And then I think that's really it in terms of scheduling efficiencies. I think pre-hearing conferences they work well for us in terms of scheduling when we need to have, a long hearing or a special set hearing, or a hearing that's going to have a lot of witnesses, because people pull out their calendars and all sit down and figure out a day when it works for everyone. In terms of Kata's suggestion that a meet and confer form be turned into the clerk with dates, from my experience, in addition to the additional undue burden on the clerks that won't work and the expense to counties that would cause, my experience is even a week or two after people submit dates that work for them, they can't hold all those dates on their schedule. So if 2 or 3 weeks later you get around to processing that particular one, and with 15,000 appeals, it wouldn't be uncommon, it would take a while to get around to processing this additional piece of paper. By then, people's schedules have changed and dates have filled up. And for example, even when we're sending around notices to parties and board members and the clerks trying to schedule a date for a special set hearing that needs an 8th day or a 9th day when we thought it would only need 7 originally, it can take weeks of people sending emails back and forth and telephone calls back and forth, because you might have a party who starts out saying, I'm available on this run of dates, but by the time other people respond at the end of the day or 2 days later, some of those dates have now filled up with other commitments and other court appearances they've been scheduled for, or their witness has scheduled a meeting for that day. And so I don't think that turning in to the clerk a sheet with what dates are available really is practical from my experience. Thank you.
Thank you. Any other partners out there?
If there are no others, this is Brianne Rabowski from CADA. Just a few very quick points, and I'll keep it brief without, trying to make an effort not to rehash anything. I'm still hearing comments where a meet and confer process that's informal and not mandated could be incredibly useful to both sides. I'm not saying that it has to be used in every case. I'm not saying it has to be used in every county. But I think a lot of these things where taxpayers aren't providing information would really benefit from this sort of process. And part of the thing from CADA's perspective is there has to be a commitment, whether formal or informal, from the counties. Once you provide that information in response to the 441D, to have the county review that information in a timely fashion and be willing to sit down and talk about the case then. And I can certainly recognize Ms. Berkman's suggestion that providing that initial tranche of information, if you will, in response to the 441D is a good way to start the process. But there's got to be a give and a take and a commitment from the counties to review and be willing to meet on that information. I'm not saying that every taxpayer requests that. I'm not saying that every county is failing to do so. But I'm saying building a system that encourages that will pick up the stragglers, both on the taxpayer side and the assessor side. In terms of scheduling, I think, anything we can do to improve scheduling, as Ms. Berkman pointed out aptly, there is a problem where you have, we'll call them empty board days or empty time, where appeals are scheduled and the schedule shifts such that people withdraw, different things happen, they resolve, and you're losing board time because you're not able to adequately backfill that hearing. And I think from our perspective, what we're saying is if we had a better scheduling mechanism on the front end, and maybe the solutions we've provided thus far aren't 100% satisfactory, but warrant some additional discussion, you'd have more fulsome hearings, you'd have better use of board time, and you'd perhaps, through the meet and confer process, have at least a bulk of appeals that are withdrawn in a more timely fashion, because you're encouraging the taxpayer to review those protective appeals and make a move so that those hearing days can be backfilled when available. So I would say, the takeaway that I take from this is we are coming at it from different angles, but we are all identifying the same problems and all saying that there are potential solutions that can be considered and should be considered for the benefit of all parties involved. Thank you.
Thank you.
Mr. Chair, this is Malia Cohen. Can you hear me?
Yes, I can hear you. Go ahead, Member Cohen.
Okay, good. Thank you. Wow, this has been really incredible.
An eye-opener, right?
I definitely. I want to speak to the last 3 issues raised after the break and just kind of weigh in here. First, it's been incredible insight from everyone. And I strongly believe that there is an opportunity to take your collective feedback and find a way to address the issues that have been raised. CADA and the local government representatives have made, I believe, excellent points. And I strongly believe that we have convened some of the brightest minds on this issue. So thank you for actively participating. I believe we've got an excellent opportunity to address efficiencies, or inefficiencies, I should say. And so, Mr. Chair, what I'd like to do is possibly, if you allow me, I'd like to make a recommendation that our respective teams take what we have heard today on these 3 issues and create language for all parties to review and provide feedback similar to today's process. Thank you.
Thank you. Let me see if there's anybody else, any one of our partners that hasn't spoken up on these 3 issues, the opportunity to give their input. Hearing none and seeing none, let me just call back up Ms. Evans. I believe you're on the line with us now, and I know you missed the beginning, a little bit of the beginning part, but you probably will agree with me that this is the one I think I don't think we had a consensus on any of the 3. We had some real good suggestions, but let me get your thoughts.
Chair Vasquez, I would totally agree with your summary of this discussion. I think there's a lot of feedback. Excellent, excellent recommendations, but as you stated, no consensus.
Thank you. Let me just double check first with Ms. Taylor and see if there's any written public input on this.
At this time, there is no written input on this item.
Can we check with AT&T to see anybody in the public?
Sure. AT&T moderator, do we have any public comments on this matter?
If you wish to make your public comments heard at this time, you may press 1, then 0 on your telephone keypad. There is no one queuing up at this time.
Thank you. Members, let me first start with where we did have several consensus items earlier. Just direct our executive director to prepare an LTA, which would include all the consensus statements that we did make earlier. And as it refers to these last 3, I would suggest, we received some very good input from folks, and obviously there wasn't a consensus, but I think that we had sufficient information to bring back a few recommendations to our next meeting. And if there's an agreement from the members, I would suggest that we continue this working group and and come back and see if in fact we could come back with some possible items after this last discussion where we might find some consensus moving forward. But for now, we will not put that into an LTA, but rather formulate hopefully some good positive recommendations for our partners to consider at our December meeting. What are people's thoughts?
This is
Vice Chair Schaefer.
Yes, Chair Vasquez, I would like to see us find some consensus today. We have lots of stuff on our plate for next month, and it looks to me like this stuff is fresh in our mind today. All parties are before us today. I would like to have some consensus today, if that's possible. Thank you.
Well, I agree with you. I'd love to have some consensus myself, but I'm not hearing any, at least from these last 3 items, a consensus. I mean, I think we've had some real good suggestions and topics to consider and recommendations. I don't know how the rest of the members feel.
This is Member Gaines.
Member Gaines, yes, go ahead.
And is there an issue in terms of timing? I mean, if we need to get the working group back together and hopefully they can come to some agreement on these issues, are we okay from a time perspective? My recollection is that our last meeting, we wanted to try to get this done as soon as we could, and there seemed to be a sense of urgency. So by delaying it by 1 month, is that create any pressures that folks don't want to deal with. Otherwise, let's just let them meet and bring it up next month.
That's what I was recommending, but I think you're raising a good point. Let me open it up for our partners. Or is Ms. Stowers, did you have any comments on this before I move it on?
Well, thank you for the acknowledgement. Well, it seems, we did hear some very good information. My takeaway was that there may be agreement with respect to encouraging the parties to participate and pre-hearing conferences, but does not seem to be an agreement with respect to meet and concur. I don't think, I understand it's been helpful for the members to hear some of these issues. And for many of you all, it's the first time you're hearing it. But from my perspective, I've heard it before for the past 4 years. And a lot of these issues, I think, are best resolved if we go back to our interested parties process and allow our stakeholders to meet with BOE staff who are experts in this area and come to resolution and bring it back to us in a timely fashion, which will most likely be next year.
Thank you. Let me put it out there to our stakeholders that are on the line. If we were to put this off, I'm sorry.
Mr. Chair, may I jump in? And I just want to ask a question to Yvette.
Sure, go ahead, Member Cohen. I'm sorry, go ahead.
Yeah, so Yvette, if this is an issue that's been going on for many years and BOE staff has been dealing with it, just by virtue of the length of this conversation and this hearing, it hasn't been dealt with. So are you recommending for us to continue with the same process? It hasn't yielded any results. So it seems like we need to kind of pivot and move in a different direction or have a different approach in addressing and solving this dilemma, the dilemmas.
Actually, to be quite frank with you, Member Cohen, BOE staff has been effective, but over the past 4 years, the process has been hijacked by external processes or external people, preventing staff from doing their job. And to be quite honest with you, I'm extremely frustrated because that is what's happening right now. I believe that BOE staff can get this resolved if we provide them with the opportunity to do it.
Okay.
And clearly our stakeholders, tax agents and tax attorneys are all committed to getting it resolved because they have spent hours and hours and days and months on this issue with us. And I don't find this process right now to be very efficient.
All right. Well, I think we're going to just disagree on this one because I would even note that even the executive director has applauded this process. And I think that it has been moving forward, but perhaps we should just hear from the stakeholders and get some of their thoughts, Mr. Chair. I'll turn it back to you. Thank you. Thank you, Yvette.
Thank you. That's where I was heading. Let me see if I can hear from the stakeholders, specifically those that are on the ground, obviously working on this, if it would be too much of an inconvenience if we allowed both our staff and yourselves and the stakeholders to, now that we've heard some real good suggestions, mull it over and come back with some recommendations that we could review and hopefully agree upon at our December meeting.
This is Brianne Rabowski on behalf of CADA. I'd like to, if I could, respond to the number of things that have been said. To respond directly to Member Gaines' question, I don't think there's any issue in allowing this to proceed to the December hearing as opposed to taking up those issues now. CADA's recommendation, as stated in our November 16th letter, is both to continue to take up these 3 new issues as well as take up a few stragglers, if you will, dealing directly with remote hearings. And those are included at the very back of our letter. What we'll do following today's meeting is we'll take the information that we've learned and potentially provide a subsequent letter, maybe winnowing some of these issues down. With respect to the debate on interested parties versus the work group objective, I would say from CADA's perspective, we are very much in favor of the working group model. It has been incredibly efficient. It's been very eye-opening for us as well to have these open forums to discuss with one another and understand the county's perspective. I think we have moved the ball forward at a very rapid pace on some really tough issues. And it's not only because of the open forum, but it's also because of the investment of the board members in this process and the commitment of the board members and the board staff who have been incredible working through these difficult topics. So to us, this process is the best process. Interested parties does have its place. It tends to be a slower process. I agree with Member Cohen that we've tried that process for these incredibly difficult topics, and we haven't gotten to a point of resolution that's satisfactory to CADA and probably is not satisfactory to the counties either. So I very much like the idea of Member Cohen, which is to take these difficult topics, allow the board staff and the members to think about what they've heard today, come up with recommendations that can be discussed further by the working group in December. I think that's an incredibly valuable process, and we would very much stand behind that. Thank you.
Thank you. Anybody else?
Yeah, this is Don Gakel, CAA. For the board members, as Ms. Stowers said, this is kind of maybe new ground for, in fairness to CADA and to assessors and to BOE staff. Some of what was brought up today are discussions that have been happening over quite some time, and issues that have affected assessors and probably applicants, and from their perspective, CADA, for many years. I don't think there was consensus expressed today in terms of these three items. And my guess is that in the short course of a few weeks here, it's going to be, it would be very difficult to form consensus among the parties involved. Traditionally, anything, especially things around any rule changes or processes, were established through the interested parties process, which frankly, we went through that in 2018 with representatives of CADA in the room and assessors and other interested parties. It was sometimes a little contentious, but in the end, we came to a resolution, at least on the formal process of things, which was to establish kind of ground rules for the 441D letter and for gathering of information, which was good. That was successful, but that doesn't ensure compliance and many of the issues in terms of gathering, getting information, getting people to supply information, getting people to discuss things ahead of time. Those problems have been going on as long as I have worked in an assessor's office, and that's 34 years now. So, some of the issues are very long-term, and changes to those are probably not going to be agreed on through this working group process in a short amount of time before December meeting. That's just my perspective.
Thank you.
This is Thomas Parker from Los Angeles County. I've been in a lot of interested parties meetings at the state board going back to 2000. And I think the interested party system, while slower than this work group process, still does have value because it not only identifies where the parties, the stakeholders can agree, but it fully fleshes out the areas of contention that the state board will have to decide because nobody else can. So I think I would not throw out the interested parties process. If the board is inclined to go with the work group process on 1, 2, or 3 of these proposed new sub-issues, I think January as a practical matter is the earliest because let's get real. We're in the holiday season. We're about Thanksgiving, Christmas, and there are other things that need to get done by everybody involved in this process. If you're in the private side, you got clients you got to work on matters for. If you're on the county side, you've got other things to do. Speaking for myself, I do more than just the Assessment Appeals Board work here in Los Angeles. So I think January is realistically the earliest if you're going to use the work group. And I would very much urge this board to not just abandon the interested parties process or the expertise and wisdom of the state board staff. State board staff is an exceedingly capable group of people. And I've worked with state board staff, again, going back to 1999, 2000. They should not be shut out of the process for a lot of these important changes. Thank you.
Thank you.
Mr. Chair, I'd like to respond. Sir.
Member Cohen?
No, thank you. No one is suggesting that we abandon the interested party process by no means of the imagination. I agree with much of what you said. I believe what we are proposing and the pathway that we're walking down is complementary to the interested party process. Mr. Chair, I'd like to share a couple thoughts, if I may.
Sure, go ahead.
Thank you, I appreciate that. So for the record, I just want to say we started this process at the request of AABs and assessors. And every month we've made great progress. And I want us to have more confidence in ourselves. We as a board have more confidence as we continue to move forward. And the reason why I'm recommending that we continue this discussion to December is that it puts our team in an excellent position to capture the feedback today and allow a proactive and healthy discussion to continue. And for the record, the processes are not mutually exclusive. The interested party process versus the work group process. As for timing, we want to make sure that we have not abandoned. We haven't abandoned our staff. So I think that board member staff probably might work a little bit faster than BOE staff, largely because BOE staff has a lot on their plate, lots of transition happening. So with that, Mr. Chair, I'd like to continue this discussion into December and hope that we are able to gather the feedback and again move forward collectively. Thank you.
Thank you. Any other comments from the members?
If I could, Member Gaines.
Member Gaines, yes, go ahead.
Yeah, I would like to go ahead and proceed forward with this work group and see if it can be distilled by our next board meeting into potential options. I want to make sure that our BOE staff is engaged. We've got the experts here internally. They ought to be involved in every step of this process. But if we've got difficult decisions to make, maybe it could be distilled into options. Option A, option B, and we can hear the debate on it and make a decision. I don't think it has to be finalized in December necessarily either. If it takes more meetings and more discussion, if I'm not hearing a sense of urgency, then maybe that could be pushed over into January. Thank you.
Thank you. Yeah, that was my feeling, members, and I'm hearing from you all, and I think we're all in agreement that we definitely don't want to end this work group, but rather enhance it and continue it. We've already set aside some time at our December meeting coming up, and you're right, we may not come to a consensus in December, but I think we might be able to chip away at some of these items in December. And then I know we're hearing from some of the stakeholders that they're going to deliberate and work through this as well. And they might come up with some suggestions as well as our own staff. And let's see on those things that we could agree upon in December, hopefully some consensus on some of these items, we can begin to chip away. And then I think there's a consensus from the members here that, you know, there's nothing wrong with continuing this into January and thereafter to make sure we try to resolve as many of these issues as possible.
Chair Vasquez?
Yes, Member Gaines.
One final comment is I don't feel comfortable wordsmithing stuff as a board. I'm not expert. I want to rely on the talent that we've drawn together through the work group. And if you've got to go interested parties, I mean, I'm open to other options, but based on what Member Stowers is saying, if we're addressing issues that have not been resolved for years and years, you know, I'm not quite sure if we can get it all resolved by December. And so, or can we resolve many of these issues in our December meeting and then move forward with a work group or interested parties option to ultimately get them all resolved? Thank you.
Thank you. Any other comments or from the members?
Mr. Chair?
Ms. Stowers, go ahead.
I think what Member Gaines is a reasonable compromise. To the extent that we have one issue that we have consensus on and the stakeholders are in agreement to, let's go ahead and address that issue in December. But for any other issue that they're extremely far apart from, I highly recommend that we put that issue back to the IP process.
Thank you.
And Mr. Chair, for the record, I just
Member
want to
Cohen,
acknowledge,
yes.
thank you, that that staff is a part of our working groups. We're not working independent of BOE staff.
Exactly. Hearing no other comments, then I think we're all in agreement that, you know, especially on those items that we did come to a consensus today, we'll have our executive director come up with an LTA for those. And then these other items that are still left for further discussion, we will bring them back in December. And hopefully by then, some of these may be resolved by both our internal staff and the stakeholders as they begin to deliberate among themselves and come up hopefully with some good suggestions. And I'm hearing and feel, and I think we're all committed that while this may not get all settled in December, that we're all open to bring this thing back and continuing after the holidays in January, given the time constraints we all have. So with that, I wanted to just, oops, Ms. Member Cohen, do you have some closing remarks? I think you're muted. I can't hear you. Unmute yourself, please.
Okay, thank you very much. Apologies. Thank you, Yvette. We didn't call on the staff. We didn't hear their perspective or share their ideas, and it's kind of like getting late in the hour. I don't know if there's a summary or something brief, but just want to acknowledge that we heard from stakeholders and we heard from our staff, but we didn't hear from BOE staff.
Not a problem. Actually, a couple of them weighed in as we were discussing these things, but sure, let me bring back, let me ask Ms. Fleming if she has any closing remarks or any comments on all the things we did discuss today.
Thank you, members. Thank you, Board Member Cohen, for your comments. And Chairman, I appreciate the opportunity to comment. I agree that this discussion has been tremendous, very valuable to me. We're hearing a lot of new perspectives. It's always helpful to hear an exchange of the ideas real time. So from that perspective, it's been very good discussion. Just in summary, I think, what we would appreciate is we want to get the work done, clearly. We want to be able to do the work with quality and giving us an opportunity to really, do some of our aspects of it, which is the analysis and putting it together, looking at RTC, PTR, et cetera, all of our rules, et cetera, and just letting us vet it a little bit more. On behalf of my staff, they clearly are informed. They're not new to this rodeo, so they are equipped to engage and can move timely in terms of their knowledge and ability. I think what we need to balance, which I think I heard others say, is just the additional workload. So to the extent that you're allowing us to have some more time, obviously we'll come back to the December meeting with those items that we've agreed to, the consensus items. We can come back with those in the December timeframe to finalize that discussion. For those items that were agreed to today, we will incorporate those into an LTA also, and then update the material that was released earlier this morning. And then coming back for those open items, after the first of the year, because I think this will not be the end of these items and discussions as we continue to focus on these remote hearings, and especially in COVID and all the backlog and the other challenges that exist with it. So I think giving us some more time to come back after the first of the year would be helpful. We are committed to it, and so we see some of the challenges and want to do our part to contribute to it. I think the balance is which forum we use. The work groups are helpful because of the public discussion, but I do want to also complement the fact that the IP process is a valuable process. So I believe what I heard is that we would be using both of those, and so it's not one or the other, but both. We would appreciate the opportunity, personally, I would appreciate the opportunity to go back and chat with my staff to kind of flesh this out, and as was requested, come back with recommendations, not just for some of these others, but just really talk about how do we organize this whole new process that we're using with IP and work groups. How do we structure that, working with my board to figure out, how are we going to make this happen going forward, so that we can give you our best, but really have adequate time for us to flesh out the issues, give us some time to think about it, and maybe collaborate with some of the stakeholders that we would do as a normal portion of our work. So I support what has happened today. It has been a delightful discussion from my perspective. I've been listening intently, in between a little bit of our technology issues behind the scene, but that said, I've been listening intently to this material, and I'm quite impressed with this body of membership and partners and these stakeholders. It's been a healthy discussion. But on behalf of my staff, I appreciate it, but we definitely would appreciate having a little bit more time to flesh out these issues, because they are complex, and we take pride in the quality of guidance and handbooks and manuals, et cetera, that we prepare. So I want to be fair to them, to give them adequate time to do their best work. So those are my comments. Members, if you have any questions, we're available to assist.
Thank you, and thank you all. I think, like I was mentioning earlier, all of us and all the comments I'm hearing, all the members here are committed to not only bring this back what we can in December, but to continue working with the working group. And I'm very grateful for the highly professional group of experts that we heard from today and have participated throughout this whole process with us. This has been going on for several months now. And I think the collaboration we've had, both from our staff and from all the stakeholders, has been at a very high level and a very professional level. And I really appreciate it, because I know on many occasions, several of the stakeholders that did come together don't always agree with each other. And I was really grateful that we were able to agree on several of these topics and issues moving forward, but still have several that we need to address and continue to deliberate on, and hopefully in the months to come we can come to a consensus on those items as well. And I really want to give a big shout out and thank you to our BOE staff and our staffs and all the respective member staff, because you all really weighed in at different levels. And I really appreciate the fact that everybody's really looking out for the best interest of the taxpayer. And I'm looking forward to hopefully resolving these few that we still have kind of pending in the months to come. And with that, I just wanted to wrap this item up unless anybody else has any other comments. We'll bring this item to a close. Thank you all. And with that, we will Ms. Taylor, I think that was it, right? I don't think we had any other items, right?
That was our final item.
Chair Vasquez, Vice
Yes,
Chair.
Vice Chair Schaefer, go ahead.
Yes, we have on the agenda as of yesterday, the election of the chair for next year coming up on our December agenda. I defer so many times to Member Cohen because of her extensive background, which I can't really hold a candle to. My extensive background was doing the LBJ administration as one of the leaders of San Diego government. But she did mention that she expects a vision statement from whoever is going to expect her vote for chairmanship. And I want to say I'm expecting a vision statement too. And if anybody wants my vote, I expect 2 or 3 minutes of a vision to be provided. And as I think yourself, Chair Vasquez mentioned, it would be appropriate to have that done in December when we're going to have the election. Thought we might do it today, but we've had such a rich and productive and busy session today. I think we're sort of sessioned out right now. So I would just request that anybody who aspires to be a candidate for chair for next year, and that's for the 5 of us because Ms. Stowers has excluded herself from that. And so if any of the 4 of us want the job, it's a thankless job for next year, please know that I expect a vision statement. I know Ms. Cohen expects a vision statement, and I think we should all do that. I think that's very productive because, and also I think we should be able to communicate with each other outside of the meeting, but because our chief counsel feels that that's a violation of Bagley-Keene, it might be the appearance of impropriety. I will accede to Mr. Nangel's views on it and not expect anybody to be mailing communications or campaign material. We'll save it for the open meeting. But I do think we have an absolute right to communicate with our constituents when we seek an office, be it chairman of the board or the office itself of a member of the board. We have a constituency, whether it's 4 people or 10 million people, we have an absolute right to communicate with them. But I will not push for that, so I'm not expecting any communications between me and any of my colleagues until we convene again in December. But in December, I'm requesting that each of us who are interested in helping run the organization next year do provide us with a vision statement. I think that would be good education for all of us. Thank you.
All right, members, that pretty much wraps up our meeting for today. I just wanted to, thank you all for your patience and your input. And we will have, actually, before we do close out, is our Executive Director, Brenda Fleming. I'm assuming you already understand that at least on those consensus items, you will prepare an LTA for those. Is that correct?
That is correct. We will prepare an LTA for the consensus items today. And then we'll circle back just if you don't mind, a point of clarification. So we'll work on we submitted an LTA this morning, released one this morning. We can take the material that we agreed on today. We can then incorporate today's material into the items released in today's LTA, incorporate it, and then today's version will supersede the one that was released earlier, if that's the board's preference. The other option is we can work on the LTA for the material agreed to today, and then clarify if you want us to wait for the December discussion and then submit a second LTA in the December timeframe. So it really is a sequence. What do you want in the LTA, the scope of the LTA, if you want a second one released today, or if you would like for us to release one in December that would contain today's discussion and the December material.
I was kind of envisioning, unless the members feel different than I do, I was going to envision that we put out an LTA for everything that we did have a consensus on today. And then after December, if there's any other agreement or other issues that we do find a consensus on, we move forward with those as well.
Okay, that would be our preference. And then what we'll do is capture all of the information. And then what we'll publish this week based upon today's discussion will supersede the one that was issued earlier today. Sorry for the confusing language on it, but the sequence of these LTAs is coming back to back here. So, but we'll make sure that we are providing them in an orderly fashion, but making sure to incorporate all of the consensus items.
Vice Chair Schaefer, I agree with Chair Vasquez on this.
Thank you. Member Gaines.
Yeah, thank you. On another subject, if I could ask for the indulgence of my fellow board members to adjourn in memory of my brother-in-law, Don Hutchinson, who died of brain cancer this morning. And he's married to my sister Margaret for 34 years. And I've got a beautiful son, and he was a good father and a good husband. And so our thoughts and prayers are with the family. And thank you for that opportunity.
Absolutely.
My condolences, yes, to you and your family, and sorry to hear that. And as always, I like to adjourn our meeting in memory of all the lives that we're continuing to lose, given this COVID pandemic we're in. And as we move forward next week with Thanksgiving, I'd like to wish all of us, the members and the public that's listening, to have hopefully a very intimate Thanksgiving. While I know it's tempting to have large gatherings, because I'm used to, I come from a large family, and usually Thanksgiving is a huge event for us, but we are, I guess you might say, downsizing this year and just having pretty much our immediate family gathering up, and just hope and wish and pray for the best for all of us, because it looks like, especially in LA County, we're really taking another turn here, and this thing's starting to spread once again. So we wish you all the best. Especially up in the Bay Area. I know in San Francisco, you're encountering similar things that we are here in LA County. And my thoughts and prayers are for all those that are infected and were hospitalized these last month here.
Chair Vasquez, Vice Chair
yes,
Schaefer.
Member Schaefer, Vice Chair.
I wanted to note that today is the first day in office of a new commandant of the CHP. Governor Newsom yesterday swore in Amanda Ray, who has something like 26 years with the CHP, as the new commissioner. Warren Stanley, who's served for decades, is retired. Amanda Ray is the second Black commissioner, the first female commissioner in the history, and there are 11,000 officers that she will command, and she starts her first day today, and I just think we should take note of that. And whenever we have a chance to drop by a CHP office and introduce ourselves, I found that their commanding officer is most interested in us and our work, and they're obligated by law to protect us 7/24, and they enjoy meeting the people that they're working for, who are us. And I think one of the treasures we have as constitutional officers is a good rapport with our CHP, and I just wanted to share my observations with my colleagues. Thank you.
Thank you.
Mr. Chairman?
Yes.
Thank you. I do apologize, because I don't like to make comments after someone makes an adjournment in memory of someone. And so first, but I did want to continue my comment on the topics that we were talking about and then move forward. So it's my understanding that we have already issued an LTA dealing with remote hearings. That LTA went out today. we're going to issue a second LTA based on the items that we agreed to today. And the goal is to get it drafted out today, but history tells me that it probably won't go out for at least 3 weeks. And then we're going to issue a third LTA following the December meeting on whatever we agreed to at the December meeting, which it will probably go out in January. I just wanted to put that on the record. And from there, I would like to say, most condolence, Member Gaines, to the loss of your brother. It's always hard to lose a loved one. So prayers and thoughts go to you and your family.
Thank you very much. I appreciate that.
That's what I have to say.
Thank you. Thank you all. And with that, I believe we will officially adjourn this meeting. I'm looking at my watch here and it says 1:36, no, 1:37, it just changed on me, is the official adjournment of this meeting. Thank you all. Have a blessed Thanksgiving, and we'll see you all in December.
Thank you, members. Thank you, staff.